Senator for District 12 and the chair of this committee. Today, we're going to be conducting our Commission on Pretrial Detention, Pre-Scheduling, and Pretrial Services. Before we get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know. As chair of the Commission on Pretrial Detention, Pretrial Scheduling, and Pretrial Services Commission, I find that due to the state of emergency declared by the governor as a result of COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-4 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and or listen to the meeting on Zoom and via phone by following the directions and links provided in the general court website. We have provided public notice of the necessary information for accessing this meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. And Alan will let you know how you can email and reach him.
Hi guys, if you are having trouble with any of the technical parts of this or are unable to view or listen to this Zoom, you can phone in to me at 603-271-3043. Again, that's 603-271-3043, or you can email me at remote senate, that's REMOTESENATE at leg.state.nh.us, and we will try to figure out any issue that you're having as quickly as possible. Thank you.
Thank you. In the event the public is unable to access the meeting will be adjourned and rescheduled. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during this meeting, which is required under the right to know law. So starting the roll call. Representative Beth Rod. So she's not here. Alan, could you also, or Jean, could you capture the results? Judge David King.
I'm here in my office in Concord and I'm by myself, where I've been for the last 5 months.
Oh, by yourself? Okay.
Seems
Thank
like
you. Thank you. Chief David Mora.
I am in Dennis, Massachusetts in my house and I am alone.
Thank you. And Representative David Welch. Okay, he's not here. Representative David Woodbury.
I'm here in New Boston, New Hampshire by myself.
Okay, thank you. Jean Haruska.
Good morning. I'm at my home in Concord, New Hampshire, and I'm alone.
Okay, thank you. Let's see. Attorney Randy Hawks. Nope. Okay, and Attorney Sean Locke.
I am here, present, and I am in my office in Concord.
Thank you. Commissioner, Superintendent Stephen Church. is not here. Attorney Tom Velarde is not here. Lieutenant Timothy Patterson.
I'm here in my office at Manchester Police Department, and I am alone.
Okay, thank you. And Judge Tina Neto is not here. Let's see. Who else do I have? Chief Paul Toussaint.
Good morning. I'm here in my office at Rochester Police Department, and I'm alone.
Thank you. Good morning. And Trixie Lefebvre.
I'm here in my home in Londonderry and I'm alone.
Thank you very much. And I'm Senator Melanie LeVake. I am here in my home in Brookline. I am not alone, but I'm alone in this room. Did I miss anybody? Hopefully not. I was reading from an email message. Got to do what you got to do. Okay, so we're going to start off. Let's see. I want to welcome Trixie and Jean once again. We are waiting for a formal letter from the governor for your appointments, but as far as we're concerned, you are appointed. The first thing we'd like to do is review and adopt the July 31st minutes. And we're going to take about 5 minutes for you to review them. I have to say that they are quite well done. So let's take a few minutes to do that. Okay, we'll just give it one more minute and then we'll move to accept the minutes. Okay, it looks like people may be done. Do we need any more time or are we good? Okay. All right, can I have a motion to accept the minutes?
I'll move to accept the minutes.
Okay, thank you. In a second.
I'll second the motion.
Thank you very much. So we're gonna have a roll call vote. And just to clarify, Alan, I only need to do a vote with the people that are here.
Yes,
Correct?
correct.
All right, that's easier. Trixie,
I'm going to abstain because I had a lot of technical difficulties participating last month.
that's true. Okay, thank you.
Yes.
And Chief Toussaint?
Yes.
Thank you. Lieutenant Patterson?
Yes.
Thank you. Chief Mara?
Yes.
Thank you. Jeannie?
Yes.
Yes. Attorney Locke?
Yes.
And Judge King?
I'll abstain. I was not able to be present.
Okay. And Representative Woodbury?
Yes.
Thank you. And Senator LeBake says yes. So, okay, so the minutes have been accepted. So what are we going to talk about today? I had a very good conversation with Lieutenant Patterson, who brought up the point that it's great to have these new laws, but if they're not communicated to all the groups, then they're really not going to be effective. So I wanted to have some discussion about what would our plan be to have these communications, the communication of the new law. And we're all from different groups and different departments. And I just would like to hear from you as far as what the best practice would be in getting this information out to our groups. So I'm going to start with Trixie because you're in the first screen. So just wondering what your thoughts are about how do we get this communicated, the changes to Senate Bill 314.
Well, the bail commissioners do have their annual meeting in the end of September, beginning of October. And typically what it's been is those appointed bail commissioners sit with their circuit court judge and the clerk. And the thoughts are with some of the bail commissioners that I've spoken with is that once a year really is insufficient to bring bail commissioners into the loop for changes or to have that conversation, the dialogue with their circuit court or their superior court judge to ensure that we are providing an effective service. So my impression, my opinion would be is that we need to have more than just an annual meeting. And especially with the changes that are coming through, but even beyond that, after these changes and it's been in place for a year or two and there's nothing coming down the road, still, even if it's quarterly, something just a little bit more often.
And Trixie, that comes from the circuit court?
Yes, we typically meet with our circuit court judge in our court.
And would that be Judge King?
I have two, my dairy court judge and
okay.
Manchester judge also. So But when we have had when felonies first came into place a couple of years ago, Superior Court did pull in their Rockingham County bail commissioners, as many, and they do make them mandatory. And so we did have some face-to-face when there was an implementation of the new policy, the new procedures. So that does happen, but it just seems from here forward, if it's possible, to make it more often than just the once a year.
Okay. Well, that sounds like a good idea. And are there any communications that go out, like newsletters or anything like that?
With the COVID, we've certainly heard from our courts a little more often with the suspension of court dates or the moving the court dates out to a 60-day time frame. So we've had a little more communication, I would say, in the past 6 months. But leading up to that, it's been just if we have a question or an inquiry, I send it to my clerk. My clerk then goes up the ladder, gets an answer, and then brings it back down and just distributes the answer via email.
Mm-hmm. Okay. Does anybody have any input to that? Like, are we seeing things that we might be able to suggest to make it better, or questions on the communication?
Well, Senator, I think that the courts can always do a better job of communicating. When the recent law changed, send out an email communication to all of the bail commissioners, and there's more than 100. And we set up the way we're doing business these days. It wasn't video, but it was a telephonic conference. We invited all of the bail commissioners, Judge Neto and I were on the call. We had some administrators on the call, and unfortunately, I think we only had 12 people call in, and I think 3 of those were court staff. So I think we only had 9 bail commissioners, and we had the notice out at least a week to 10 days ahead of the call. So I was frankly kind of discouraged that we didn't have more participation. So I think maybe we need to send a survey monkey to the bail commissioners or find out what ways of communication would work best for them, and we can be flexible. COVID has clearly turned us upside down in terms of our ability to schedule in-person hearings and meetings, but we need to find a way until we're beyond this to go to the bail commissioners and make sure that they have the information that they need to do their job. We have had quite a bit of feedback from bail commissioners around the state in terms of how they've been dealing with the COVID pandemic in terms of setting bail remotely. Some of that feedback has been very helpful, and I know there's going to be a committee or commission set up to look into that more deeply, and I think it's going to be great. We look forward to working with them on that. We're working on the protocols and the programs for the September-October meetings, and whether those are done in person or by video or by telephone, it remains to be seen. Some of the education can certainly be centralized, and we think we can maybe put on a more robust program if we did it centrally rather than just locally with the local judges. But getting feedback from the bail commissioners is always helpful, and they all certainly have my email address because I do hear from them. So we'll be looking at that as we move forward. We have said at this commission more than once that we need to do a better job of educating all of the tools in their toolbox to do the job.
Okay, thank you. It seems to me also that when a new law is passed, it's going to be really critical to get, if there are any changes, it's going to be very critical to get that to all the bail commissioners. And not just the bail commissioners, but to all the parties. So that might be a more centralized role for someone.
Right, which we have already done. We've already sent out some communication to the bail commissioners, and we send out legislative alerts anytime there's a change in the law, whether it's bail commissioner or any other substantive change. Go to the clerks and the judges, and those are available to folks on our internal website too for our court staff. But we have those materials available, and the bail commissioners have already received some communication from us on the current changes.
Okay, great. Are there any other feedback on this? Representative Woodbury.
Thank you, Madam Chair. My comments don't go only to the bail commissioner issue, but the gold standard of what we do is going to be contained in the report that we file at the end of this process. And that will include work with the bail commissioner and with the bail setting and with the pretrial standards that we've been talking about. And I think a very good thing to do would be to publish that that report when it's produced, with as much explanation about it as may be needed. And I would suggest a very good medium would be the New Hampshire Bar Association publication, and particularly sending to the attention of the special, I've forgotten the exact name of it, but the special interest group of practitioners in the criminal defense and criminal prosecution field. I'm sure Attorney Locke would know the ins and outs of that better than I would. But I think that we'd get a very good exposure to what we've done, and I can't think of something better under the circumstances.
Okay, thank you. That's good input about publishing it in multiple places that would need to know. Jeannie, you have a virtual hand up?
I was just gonna know, one of the, I think, challenges that we've had in the past is that different stakeholders interpret the law differently. And so I'm wondering if one of the things that I think would be helpful is if there is kind of a universal like translation of the law into like, what does it mean in practical terms? So everybody's on the same page. You know, we've been working on bail reform for going on 3 years now, and I feel like we're constantly trying to reach agreement on what it means. And so Judge King, if the courts do work up a like kind of layman's interpretation of it, I think sharing that really broadly, so people are speaking the same language, they're understanding the law in the same way, would be very helpful. Whether that's kind of sending it to all legislators and, you know, sending it around to relevant groups. I know, speaking for the ACLU, it would be very useful to kind of understand how the court is interpreting it and what instructions the courts are giving to other relevant stakeholders.
Okay. Trixie?
And that being said by Jean, I would like to know if we could encourage a two-way conversation when the implementation occurs. In that way, there can be fielding of questions and a general opinions can be shared in and amongst one another. Because I do know that the recent meeting that we had with the court, and that's appalling that we only had 8 or 9 bail commissioners call in that day. But it was a one-way conversation, so there was no opportunity to have follow-up with that, with the new implementation. So I would like to encourage that it be a dialogue back and forth.
Yeah, and so if I could just respond to that, Trixie, thank you for apparently calling in that day and getting our numbers up almost to double digits. We thought we were going to have 100 people on the call, and so even when we have calls with our clerks and there's only 18 of them, it's hard to have everybody off mute. So that was the reason for that particular call. It was really just to get the information out, but clearly when we do the education, it will have to be two-way. We did, if you recall, ask the bail commissioners to send in advance any questions that they had, and we did get some questions and tried to respond to those on the call. But when we dig down in deeper into the substantive changes, it will have to be a two-way conversation. We recognize we'll figure that out.
And Trixie, is there a way to rally the bail commissioners around these events? You know, like Judge King said, like, let's figure out how they communicate. What are your thoughts about that? I
have made attempts to have larger conversations with the bail commissioners. For example, when we had talked in January or February about my gathering up information, some real data about the unpaids and all of that, I reached out to, as Judge King has pointed out, probably close to 85 bail commissioners and received 8 to 10 responses. And then as I was dispersing the information about the House bill, the Senate bill that was going out, what I would get was, you know, thanks for the information. but that's all I was getting. So I do believe that we have some, it seems as though a good majority of bail commissioners that are just going to wait for the system to get fixed without participating in the system being fixed. So sadly, I have the same response that Judge King is speaking of when I tried to rally the forces.
This seems like it's a result of the bail commissioners not really being owned or reporting to, like we report to the courts, but there's no other, connection, like financial connection. But that's another bill. Attorney Locke, what are your thoughts about this, since we're all in the court system?
So, at least from the practitioner side, I mean, I think Representative Woodbury's comment for outreach is a good one. I would maybe, instead of or in addition to the report being filed with or distributed to the criminal law section, which isn't, just from the couple years I was participating, isn't a particularly active section, perhaps even a short article or something like that in the Bar News highlighting reform, because that goes to all legal practitioners in the state. And so that's something that everyone would receive. And at least they would all be aware of the changes. I mean, it may not be able to get into the substance of what the practical changes mean, which goes to, I think, Jeannie's point, because, well, I would love for someone to be able to create something that clearly defines what the bill means. Ultimately, the New Hampshire Supreme Court is the final say on what the law means and how it has to be applied. And so until we really have decisions from them, anything that gets distributed is subject to challenge and change. And so that makes it a little challenging kind of at this stage to say this is what the law means. I mean, we can certainly say this is what we intend it to mean, but the New Hampshire Supreme Court doesn't have to accept that. That doesn't bind them in any way. In terms of certainly outreach to prosecutors, I think that on our end is a little easier. Every year, the past 2 or 3 years, I've done trainings with prosecutors at the New Hampshire, within the partnership with the New Hampshire Coalition for Domestic and Sexual Violence on legislative updates. Our office regularly meets with all the county attorneys. Obviously, County Attorney Velarde is also on the commission, so he is able to do outreach to the prosecutor or county level prosecutors as well, and also to the county attorney to pass the information along to the district court prosecutors that are around the state to make sure everyone's informed about the process. And I would assume if you were here, Randy would say something similar, with the sense that the public defender program will obviously be very aware of the changes. I think the only tricky part may be kind of the private practitioners of criminal law, especially those who may have a kind of heavy caseload in criminal law. But I think perhaps outreach through the Bar News and the Bar Association could be a way to get that information to them as well.
Very good. Thank you. And on the law enforcement side, I'm going to ask Lieutenant Patterson first, because it was actually your idea to discuss this, which is a very valid and very good idea. What are your thoughts?
Morning, Senator. So in terms of distribution, I agree. I think that we should get the information out to as wide a group as possible to highlight what we've done and what the changes are. I would agree with Attorney Locke with regards to interpreting the law. I don't think that any one person can sit there and say this is what the law means, as each judge ultimately comes down to making the interpretation, and then that's when those appeals go up to the Supreme Court. The Supreme Court's the one that says, okay, this is what the law actually means. We certainly can, or the legislature certainly can say, this is what our intent is for the law, but the judges are the ones that are charged with interpreting each case as it comes in, and the Supreme Court is the one that's charged with making sure that everything's constitutionally valid and to just say actually what it is. From a law enforcement perspective, I would say that if we could get notification, and I don't know what the mechanism is from the court regarding changes that come out, the legislative kind of updates, that would be fantastic, so that we could make sure that, so like my prosecutors are on board with it. I know that in the last, certainly with this, when this bill, when it was signed by the governor, there's still not, we can't access anything online that says, what the change to it is. I have all of my paperwork from working in the commission, but to get an actual clean version of the bill, I haven't found that yet. And I don't know if there's a simple way that I could access that to be able to say, okay, hey, Judge Lyons, here's what the bill says. To be able to interpret it. When my chief asks, I can hand it to him and say, okay, here's what the bill is. This is what it says. If the county attorneys are having a question on it, here's what the bill says. So I don't know if there's a place outside of, trying to dig down through Google and go through all the various law sites from the state of New Hampshire. Is there some place that has the updated changes and when those come out? Because the governor signed this earlier this month. So that was my question, and that's why I brought it up to Senator LeBake.
It's about 3 clicks, Lieutenant, on the legislative website, New Hampshire Legislature's website. You just get to their face page, and then you can put in the House bill number and click on it, and maybe three clicks you'd have the current version of the bill.
Okay.
The whole docket of the bill, the history, very user friendly. That's where we get all our information.
Okay, very good. Thank you.
It seems like, I know it's on the general court website, but it seems like you shouldn't have to go there to find out information that impacts law enforcement. So I'm not trying to duplicate, but is there another place where that's held that is more focused on law enforcement? Does anybody know that?
I won't speak for what individual police departments have, but I'm pretty sure it's it varies. It would vary from certainly police department, county attorney's office to county attorney's office. There's no kind of centralized repository for all information that every law enforcement agency has access to. And in that sense, in this sense of kind of
like the bills that impact their job. I know there are lobbyists for the different departments, like the police chiefs and
right.
The troopers. They don't have this is the latest on bail reform.
Chief Toussaint would know better, but from my experience with Beth, she just does kind of individual outreach to the chiefs. It's not I don't know though. I don't want to speak for others, but I know we can do kind of a distribution to prosecutors across the state, but it's an email, so it ends up in their inbox, but it's not, they have to search back through that or save that somewhere to find it and pull it up.
Mm-hmm.
I can tell you that Beth does a great job communicating with the New Hampshire Chiefs organization with any legislative changes. And there is a distribution list within the New Hampshire Chiefs. Information about new legislation does get disseminated through all the members of the New Hampshire Chiefs.
Mm-hmm.
With regard to this specific legislation, I think it's really important for the individual court within the state to really put something out to say to law enforcement, to the bail commissioner, this is our interpretation of this, and this is how we would like to keep things handled moving forward based on this new legislation. I think that would be incredibly helpful. If there was, someone, I think Jeannie said a layman's version of summary of the changes to the law. I think it would be important because each court does interpret, or they tend to interpret things a little bit differently, depending upon which judge is presiding. So I think it would be very helpful to get everyone on the same page with this. If each court or maybe the here coming from Superior Court to say this is our interpretation of until someone says differently.
Okay, so we're looking to the courts to give this clarity and layman's terms what this means.
That would be my suggestion, and it's only a suggestion, but ultimately the judges in these courts are going to make decisions based upon their interpretation of the law.
And I think that happens every day in every circuit court, certainly in the state where bail arguments are made. And the local prosecutors and defense attorneys generally figure out pretty quickly what the judge's interpretation is. We, as myself as an administrative judge, can't tell judges in the circuit court how to interpret the law, nor when we send out information, we tell them that we say, here are the changes, and really it's up to the individual judges until, as a couple of other people have mentioned, the Supreme Court says with some specificity, this is what this means. It's subject to interpretation, and that's really up to the individual courts. But for them to like send out some kind of a notice to the state, I think would take away the neutrality of the courts. They have to send it to every self-represented defendant and every defense counsel too. I think the way it happens in real life is that bail arguments are made when changes are made in the law, and everybody figures out pretty quickly what the local judge's interpretation of the change is. I think that's how it works.
And I think in this bill, it really states that the judges have that ability to make, the decision based on the evidence, their past, etc. So it does give the leeway to the courts and to the judges. We got a couple hands up. I know Representative Woodbury, you had your hand up. And I think that, just one second, I think Jeannie had a response to what we were just saying, and then we'll go to you if that's okay.
I just want to know, I think we understand that every judge will interpret this differently, but the court is providing something to bail commissioners. Like, the court is developing some sort of educational material about this law. So I don't think we're talking about anything other than that. Like, whatever is being shared with bail commissioners to help them understand 1645, having that be widely shared, because again, it's not the final word. It's not saying this is how the bill will be implemented. But the average person who reads legislation doesn't know what they're looking at. And so just having the basics of like, this is what bail commissioners are being told. And if what bail commissioners are told is what law enforcement's told, is what advocates are told, I think that would be helpful, recognizing that it's a moving target as it's interpreted over time.
Yeah. Okay, thank you. And I didn't mean to cut you off, Chief Toussaint, and we'll go back to you. But Representative Woodbury had his hand up as well.
But thank you, Madam Chair. I agree with Judge King that the court system is probably not the best place to disseminate explanatory material. And I think the reason for that should be pretty clear, and he's made it clear. But a very good place is the umbrella organization for all of the law enforcement efforts in the state, and that's the New Hampshire Attorney General. And I don't wish extra work on Attorney Locke, and I don't think he'd be the one to do it anyway. But I think the New Hampshire Attorney General, of course, closely monitors the work of the legislature and these committees, and is uniquely well positioned to present the state's interpretation. Now, whether that would go all the way down to bail commissioners or not, I'm not certain, but it would certainly cover all of the police and law enforcement community. And it seems to me that the place for that is uniquely set on Capitol Street in Concord.
Thank you. Any thoughts, Attorney Locke?
So I don't disagree with that. And that's what we've done in the past as bail reform has moved along. We've provided guidance to prosecutors, particularly prosecutors. I mean, we can also do so to police departments as well, but we've done focus on prosecutors who have to stand in court and argue the issues. We've done that historically, and we will continue to do that going forward. But that, that will give them kind of the parameters of how we view the law, but it doesn't necessarily mean that that's ultimately what happens, which I know can often be a source of frustration for prosecutors. They say, well, I did what you told me to do and I lost anyway. And our response is, well, that's how the chips fall sometimes. But that is certainly something we would do, but it's not going to be anything until, again, we have a final word from the New Hampshire Supreme Court that would bind any sort of future decision or really have any sort of, it would have a solid foundation supporting it, but that doesn't mean that it won't happen. We certainly will do that forward.
And maybe if it's even just getting the information out, you don't have to interpret it, but that it's, you could be a central repository to filter that information down.
Right, and we do that, and we have, in the prior to the kind of the changes that were made this past back in 2019 at the end of the 2018 or the 2019 legislative session, we issued guidance. I drafted and wrote some guidance for prosecutors on how to interpret this and kind of how to make arguments with these new changes. And we have Attorney Rotman, who is the training prosecutor for the state. And so he's also a great repository for distributing and disseminating information like that to prosecutors around the state. So we certainly have the means and resources to do so and plan to do so as we usually do.
Good. Chief Toussaint, I wasn't sure if you were finished with your remarks. Would you like to add anything else?
No, you didn't cut me off, but I do have a question, I guess, and a comment. To me, it is critical that all the bail commissioners get the same type of training on this law. I don't think I'm not as concerned with the judges, and I understand that the judges have their own interpretations of the law, and each court has their own interpretation based on who decided. But if someone gets bailed by a bail commissioner who predominantly works in the Rochester court, and they commit the same type of offense, and they're bailed by someone in the Dover court, I think that those people, the offenders should be the same type of criteria placed upon them by each bail commissioner, whether you're in Rochester, Dover, Salem, wherever you may be. So I understand that the judges will interpret things differently, and we can't tell the judges, this is how you will do these things. But the bail commissioners, unless I'm mistaken, are getting direction.
Could I comment, Senator? I don't know how to raise my hand, so I apologize.
Okay, you're fine.
So two things. One, to Jeannie's point, in terms of getting the word out, we clearly have the obligation statutorily to get the word out to bail commissioners about the law and how we see it and give them guidance on interpretation, because they're agents of the court, even though they're not our employees. So we do that. We don't have the same obligation to the police officers or defense attorneys. So that's point one. Point two is, as with judges, bail commissioners have a certain amount of discretion too. So it's not a cookie cutter, one size fits all, simple assault with bodily injury, it's going to be X. They have to take the facts as provided from the police officer on the night or afternoon of the arrest and determine what criteria they're going to apply and set bail in a fashion that they deem their discretion to be appropriate. So give them guidance, but we don't tell the bail commissioners or the judges. And I think as someone commented at the last meeting, reading through the minutes, it's really fact dependent. And what I think Attorney Locke would be doing is giving the state police officers and agents guidance on how to argue the particular facts in the law to try to get the result that they want, whether it's preventative detention or cash bail or whatever it may be. But there are no two cases that are the same. And so there's discretion both on the part of bail commissioners and judges on a case-by-case basis.
Yeah, that's a good point. Trixie, did you want to comment on that as our bail commissioner?
No, I concur with Judge King and Chief Toussaint. I have always, in the 11 years that I've been doing this, I've been under the impression that if I was doing something that my judges did not think it was the correct course of action, and if I was doing this over and over again, that I would be spoken to, called in, had a conversation with. And so I think that there is the one-on-one relationship that needs to exist between the bail commissioner and their courts to make sure that we are following the guidelines, following the laws, to make sure that we are implementing what we in the proper way. So I think it comes down to a relationship that these bail commissioners have with their courts. So I don't think that there can be a written down one point, one way to do something. It has to be, each case is different, as was mentioned in the previous minutes. And as a bail commissioner, I do have conversations with the arresting officer, or I will be reading the report that the arresting officer has prepared to make sure that I understand what has happened leading up to the arrest so that I can make a decision.
Okay, thank you. Chief Toussaint, all set? Okay, and Chief Mara.
I also agree that the bail commissioners are probably the most critical group of people that training needs to get out to. If you look at all the issues that have been, most of the issues, there have been some in court with the interpretation of the bail reform bill before it was recently amended. A lot of it comes down to the bail commissioners, where people were being released and there was no consistency across the board. And I do agree that it's critical that they are the ones that get the training, and with the understanding, as the judge says, there are different circumstances, different facts, and they're not just going to, for particular crimes, they're not just going to say, hey, that's a $500 castle surety, but that is where it's critical. And as far as training police officers to know about the bail law, the way the system works, I think it's important that police officers understand what the bail law is, but in the process, they're really not involved in that process. They present their case or the facts and circumstances to the bail commissioners. They're not in the decision-making process. So it's good that they should be aware so they know why decisions are being made, but it's not as critical as the bail commissioners.
Mm-hmm. Got it. And we determined that it's the courts that will be providing this information, and the request is that there is communication quarterly. I heard that from Trixie, more frequent coordination or communication, excuse me, and an opportunity to give feedback to the changes in the law. Is it working? Is it not working? So this was very helpful. So I appreciate that conversation. And are there any other thoughts that you want to express before we close out this piece? Representative Woodbury?
Yes, I guess I want to make 3 points, and I'm going back over the entire process that we've gone through for months. In my view, it seems we have resolved the issue of bail per se by the statute that we recently agreed to pass and has been passed and signed. The second point is that I don't know that we've ever resolved the problem that I see coming, that bail commissioners are frequently, or maybe hopefully not frequently, but sometimes simply not paid. They're paid for the indigent defendants, but they sometimes get stiffed on the people who are not indigent. My feeling is that the work of the bail commissioners is central to the entire criminal justice process, and that they shouldn't have to look here and there, up and down, for their fees, and that the fees ought to be a burden on the state treasury. That's not the case today, but it ought to be. And thirdly, especially at the last meeting we had before this one, we talked about the disparities between counties and the pretrial service levels that are afforded to different people. I feel that the levels of service should be determined and applied statewide, and not county by county. And to the extent that becomes a charge on the state, it'll just have to be that way, rather than letting county commissioners or county sheriffs or whoever it is in any county make a sort of patchwork quilt of services that could differ all over the state. So those are the 3 points that I want to make. They're not necessarily connected with today's discussion, but I did want to get them on the record.
Well, Representative Woodbury, I thank you for that. I'm very much in agreement. I think that there was a lot of consensus around the table. I'll take the third one first. about the pretrial services. In our last meeting, I heard a lot of consensus about, in a perfect world, this would be a statewide effort to have pretrial services. We may not be able to do that just yet, or it may be a matter of the priorities of those that are, in our government. But it's a good goal to reach for, rather than just to have individual, some organizations or counties having pretrial services. And also understanding that not all counties can have that same level, but maybe we should at least have a minimum level. I believe that's what I heard from most people in the last meeting. Am I correct? Do we all kind of agree? I felt good about that meeting because I felt like, yeah, we've got some consensus here. We have a proposal here, even though it's not something that we may not be able to do right now because of COVID, because of our economy. This is the aspiration. This is the goal, to be like Stratford or Rockingham. So, yeah. We don't have to take a vote, but I'm just looking for some more nods. Okay, that's, I love it when people do that. So the other thing is about bail commissioners getting paid. There was a bill from Senator Carson, and she is, in that bill, she advocated and asked legislatively that we pay bail commissioners depending on our fiscal position. And it really is our goal to have their pay included in our budget. So that's what we want to look at next session, is to be able to put their pay in the budget. So we're working towards that for sure. Let's see. Speaking of the pretrial services, one of my goals for our meetings was to have different organizations, like someone representing homeless, someone representing substance misuse, and someone representing, what's the third one? I'm missing one. Oh, mental health, so that they could talk about their environment. I know there are some, like Stratford County is utilizing programs to help these areas already, but I think it would be helpful for us to hear a little bit more from them. And again, knowing that we may not be able to do this, but at least we understand more about what it is. And to me, that kind of puts a bow on this. It wraps up what we're doing. And I'd like to strive to have those groups come to our next meeting. And then we're going to be closing out. We have to have a report by November. So we'll be thinking, we should all be thinking about, like, what are our recommendations? What are our, our aspirations? We certainly don't want to change the law right now, or maybe we do if there's a certain area that we find. But, we want to be able to deliver a report and have a holistic view. So I will be working on getting some people for the next meeting to talk about those 3 areas. And I think the last thing that we wanted to talk about was the failure to appear analysis. And Judge King, were you going to talk about that, the information we received?
Sure, I'd be happy to. I think Judge Neto sent it out yesterday to you, Senator. So what everyone should have, and I had to blow mine up so that I could read it because it's pretty small print, but members of the commission will remember Megan Hall, who came and met with the commission back when we used to have meetings in person, and had been hired as the bail coordinator with the really ultimate goal of rolling out our text messaging program to criminal defendants to give them prior notice of court hearings. And she had been, what we wanted to do was get a baseline on the failure to appear rate before we rolled that out. And so what Megan was asked to do in 2 courts, Hillsborough Superior Court North and Chief Toussaint Court in Rochester, was to look at data for a period of almost 2 years to try to get a sense of what our baseline was, and also to see what effect bail reform has had to date. So I'm looking at the Rochester data which we sent out, and this is, I would call this a small, medium-sized court. So it's kind of in the middle, but on the small side in terms of volume. But pre-bail reform, so February 2018 to August 2018, the overall failure to appear rate was 22%. And then we looked at the next almost a year up until the Hill case. It went up to 26%, which I think is probably not a surprise. We've heard anecdotally from folks, including lots of police officers, that more people were failing to appear, more people were being released on PR bail and not showing up. And then the last column, the last 170 days, was after the Hill case. What we might have expected it to go the other way, and in Rochester it didn't. The failure to appear rate continued to go up. It stayed flat in Hills North. So at Hills North, overall, it's a lot lower. I think that's probably explained because a lot of people in Superior Court have counsel earlier than they do in the circuit courts. But again, with bail reform, the failure to appear rate did tick up and stayed pretty flat from that point on. So I'm happy to answer any questions that you have, but I think the charts are pretty self-explanatory. Both in the Superior Court and in the Circuit Court, the highest failure to appear rate are for post-sentencing type hearings. So those are maybe contempt hearings or failures to make payment on fines or whatever. There's a column on the right-hand side of both charts that breaks down the arraignment categories, the pretrial trial categories, and the post-sentencing categories. I guess anecdotally in Rochester, which the failure to appear rate is pretty high to begin with, I would have expected more of an uptick in bail reform just on anecdotal information. But these are real numbers. This was done very methodically by Megan, and I'm pretty confident in these numbers. I will add this, again, somewhat anecdotally, but we're in a different world right now with COVID. We're not doing in-person hearings by and large. What I think we're seeing around the state, and I've talked to a number of judges, is that our failure to appear rate with telephonic hearings is much lower. People are able to take a break from work and call in for a status conference hearing or other type of hearing, where before they might just not show up in courts. And I think this is a nationwide, I mean, we've been reading about other states where they're finding the same thing. It's a lot easier for someone to appear for a telephonic hearing than to take time off from work and maybe sit in the back of the courtroom all morning because there's 90 arraignments. But if their hearing is at 10 o'clock, and it's a telephonic hearing, it's at 10 o'clock. And they can plan accordingly and maybe take 10 minutes out of the day instead of a half a day. So it must be 11 o'clock.
Okay.
So when we get to the other side of COVID and whatever the new normal is, I think we'll be looking closely at how we can use what we've learned in the several months and maybe make it easier on people to have access to justice and not be so disruptive in their lives. And I think telephonic and video hearings is something that we'll be seeing more of. I think lawyers are going to say, well, why do I have to drive to court to do a plea in a DWI when I can do it by phone and it only takes 15 minutes and saves my client and me time and money. So that's just an anecdote, but I think there's a lot to come out of the COVID pandemic that may have a positive spin to it.
Yeah, I have to agree with that. It just makes so much more sense now that we've utilized this. We know that it works. In the State House, it allows people to go to hearings who, maybe way up north, they never would have driven down for a hearing, but yet they're able to participate. So hopefully we will pick up on some of these new technologies that are making things more efficient. I think that's good to know. Do you know if Megan is going to be replaced? Are we going to get anyone to crunch these numbers for us?
Well, we're in a hiring freeze right now. That the governor's imposed, and we've agreed to go along with. Our text messaging program is pretty much ready to go. She had that pretty well developed. The problem is we're not having hearings, so we won't send text message hearings to appear in court when we're not having in-court hearings. So I think when we get to that phase, we'll pull Megan back in. It still works for us. She just works in a different department. I think we'll still be able to launch the text messaging when we get back to in-person hearings, but it really doesn't make sense to do it at this time because we're in such a different world.
Yeah, that's true. Well, thank you for sharing that. Are there any questions on the numbers or observations? Hopefully we can bring those numbers down and get somebody to track it for us.
That's
Okay.
the plan.
Yes, all right. So, is there any other business that we need to discuss? Are there any concerns or anything that anyone would like to share on the call?
Senator, just can I ask, how do you envision the report getting drafted? Are we going to have some subcommittees that break it up into chunks, or are you going to write it and circulate it, or?
Well, I was thinking of taking a stab at it with some assistance from the committee. I don't know if I don't really see it being like a huge report. We can use all of our minutes as the backup and then do an overall report. But I would like to have some assistance, and maybe we could have like a subcommittee to work on it from different areas, the courts, law enforcement, bail commission. So I'll have to give some thought, but I'm really open to any suggestions that you have. Okay. All right. Well, so our next meeting, we have to schedule our next meeting. Let's see. Look at November, September. September 18th would be our next meeting. That works for everyone?
I just see on my calendar that it's Rosh Hashanah, which to me is not an issue, but it might be an issue for some people. I just,
Yeah,
for what it's worth.
sure. Well, what about the 25th? What's on your calendar on the 25th? If that looks clear, we can go with the 25th at 10 o'clock. Okay, so hearing no other concerns, let's just mark that as the date for our next meeting. And I'll work on getting some of the resources from the 3 areas that I had mentioned. And I'll look forward to seeing you all. Don't forget to vote. Okay, get your absentee ballot in soon. All right, so thank you everybody for joining us, and we'll see you next month, okay? Take care, bye-bye.
Do we have to have a roll call
Thank
to
you for
adjourn?
saying that. Yes,
I'll move to adjourn.
thank you. Okay, so Trixie? Yes. Chief Toussaint,
Yes.
Lieutenant Patterson,
Yes.
Lieutenant Mara,
Yes.
Jeannie,
Yes.
Attorney Locke,
Yes.
Judge King,
Yes.
Representative Woodbury,
Yes.
and Senator LeVake says yes, and thank you. All right, all
All
right.
right.
Take
Hey,
care, everybody.
Senator,
Have a
Senator
good
LeVake,
weekend.
Senator
Yeah.
LeVake.
Yes.
So sorry. It looks like Alan might have dropped off. I'm not sure. I don't see him. So you've been promoted as the host. So you'll just need to be the one to end the
Okay,
live stream. You should see the button that says it on your screen.
got it. All right. Thank you very much. Thank you, Ava.
Of course.
Bye, everybody.